are you all tonight? Good, good, good. That was good and strong, actually. I wasn't expecting quite that this time of year, but that's great. Garrett Dodd, okay, you have White versus Revco here in just a minute. Miss Hill, Lisa M. Jeremy Clark, Mr. Clark. How about Youngblood versus Wall? Olivia Lindsay, Miss Lindsay. How about Driver versus Smith? Amber Jenkins, where are you? How about Star versus Hill? And if we don't get to that tonight, we'll start there next week, okay? All right, so last time we were working our way through respondeat superior, which of course is the principle that makes employers vicariously liable for the negligent acts of employees committed within the scope of the employment. And we have a couple of cases left over from that discussion that we need to spend some time on. The first one is White versus Revco. So, Mr. Dodd, the floor is yours.
All right. So, White versus Revco was in 2000. The opinion actually kind of started with some background knowledge. There was kind of two separate events. So on May 4th, 1997, inside a Revco, which I actually didn't really know what that was. Apparently it's like a CVS. It was like a drugstore. James Woodfin ends up being the victim.
You didn't know what Revco was?
I didn't. I really didn't.
Oh, everyone in the world knew what
No,
Revco
sir.
was. How many of you knew what Revco was? Okay. Five, all right.
Something like.
Where I was going to say, where the rest of you live.
Yeah, I know.
But you're right. It is a drugstore.
But Mr. Woodfin, he caused a disturbance on that day, and Danny Boone, which was the security guard on that day, he issued him a citation. They then revealed that he was their security guard, but he was also he was a part of the Knoxville Police Department. So he was off duty when he was working, but he was also a part of the police department. And that day they issued him, they told him to never come back. They trespassed him from the Revco. But then on June 4th, not too long, it was about a month later, Boone was working at the Revco, and he was approached by the manager, who was told that Woodfin had actually come back. It was a few days prior, it was like 3 days before, but they said he came back. So he then called the police department to figure out what had happened with the citation that he had given him about a month before. And he actually figured out that Woodfin never went and turned himself in. He never booked himself for the citation. Um, So there was a bench warrant that was issued, and when Boone figured out about this, he informed the manager at Revco, and the manager then took it upon themselves to tell him to go to his house and serve him on this warrant. And it was the manager that told him, which became important, but it was the manager, not the police station, that told him to go get it. Before he went to his house, though, he contacted 4 or 5 other officers with the Knoxville Police Department to go with him.
Why? What do you infer from that?
I kind of inferred
You called 4 or 5 other police officers.
I think they were ready to do something.
Well, I mean, what does that mean?
Like, I think that, I wouldn't say that they thought he was dangerous, but they were, like, he was, I don't want to word it.
I see that. My immediate thought is they suspected trouble.
That's a good way to do it.
One guy should not show up at the plaintiff's residence. They need to take
4 or
several.
5. Yeah, I think that's a fair way to
Boone
put it.
suspected this could go sideways, and we need to show up with some force.
Which is probably fair, because they had the first run in the previous day, so that's a good way to put it. So they show up his apartment, and they noticed that he had locked himself inside the apartment. They kind of knocked on it and then tried to kind of open the door, and it was locked. One of the officers called the maintenance department for a key. And while they were waiting for the key, the Revco manager actually called Boone and asked him to return to the store because there was somebody in there that they needed to cite for shoplifting. So Boone goes back to the store. While they're waiting on this key, he goes back to the store, issues them the citation, and then he comes back. They still haven't entered the home. They're still waiting on the key. They finally get the key, and once they enter the home, they realize that Woodfin's he's locked himself in his bathroom. Woodfin then, he warned them that he had a shotgun pointed at the door and that he would shoot anyone that entered the bathroom. One of the officers then decided to kick in the door and fired his weapon at Woodfin, and it ultimately killed him. It was at this point that they called their supervisor at the Knoxville Police Department and told them what they had just done, which I thought was a lot.
You thought what?
It was a lot. Like I had the assumption that someone at the police department knew what was up, but they actually had no idea until at this point. So White filed an action. It was a wrongful death suit. He sued it was Boone, Revco, the Knoxville Police Department, all the officers involved, the city of Knoxville, and the Knoxville Community Development Corporation, which leased the apartment to Woodfin. They alleged that the officers were negligent in using deadly force and that it was unreasonable and unnecessary for a misdemeanor arrest. The trial court actually granted Revco. They filed a motion to dismiss the wrongful death action, and that was granted at the trial court. And the Court of Appeals affirmed this dismissal, holding that the off-duty officer's actions were taken in furtherance of his official duties as a peace officer, and therefore Revco was not liable.
So Revco is the focal point of this appeal.
Yes, sir.
Right.
Yeah. Everything else was good, but the Revco is what really they focused on.
What is the plaintiff's theory? What's the plaintiff's argument as to Revco?
The
How is
argument,
it that they say Revco is liable for this?
if I'm remembering correctly, it was because it was Revco's manager that told him to go serve this warrant. So Revco was the one that started this chain reaction. It wasn't.
So is the plaintiff's theory predicated on Revco's negligence?
I would say yes. That's how I
I would
interpret
say
it.
no. That sets up the whole problem.
Well, I guess it would actually be.
If it was Revco's negligence, this appeal would have never been necessary. So the plaintiff's argument is Revco is liable, not because Revco did anything wrong, but
Because Boone was.
because Revco is vicariously liable for what Boone did as an employee based on respondeat superior principles. So there's no allegation here that Revco deviated from a standard of reasonableness. Had that been the plaintiff's theory, the court would have never gotten to respondeat superior / vicarious legal responsibility. Okay, so you mentioned the trial court, you mentioned the Court of Appeals, Supreme Court grants review. What is the issue here? Why did the court grant review?
The generally is, can Revco as a private employer be vicariously liable for negligent actions of a police officer that's off duty who they have employed as a private
Exactly.
security guard?
Yep, that's the issue before the court.
Yeah.
And in analyzing this issue of first impression, you see that the court, as it does often with issues of first impression, look around the country to try to get some sense of how other jurisdictions have addressed the same problem. And when the court does that here, we're told that there's a majority rule and a minority rule when it comes to this issue. That is, can a private employer be held vicariously liable for the negligence of an off-duty police officer employed by the private employer? So how's the country divided? What's the majority rule? What's the minority rule?
From what I remember reading, the majority rule is that they can be held liable. It's kind of like any other employee-employer relationship.
It's the opposite.
It's the opposite. I remember the majority would then be that most of them, if they're working for like their personal agenda is a good way I would probably say it, then that's the majority of jurisdictions. They can be held
majority
liable.
rule, the majority of jurisdictions view a situation like this as the tortfeasor himself or herself acting in an official capacity. A police officer is a police officer 24 hours a day, 7 days a week. And so in a case like this, the majority of states would say that the private employer is not vicariously liable, but the public employer would be. The minority rule then is just the opposite. That is, private employers may be vicariously liable. Which side of that debate does our Supreme Court come down on?
They're more in the minority. They focused on the control, direction, and the consent over the actions. So in this specific case, since Revco was the one that told him to do this, they were the one that directed it. They gave him.
hang on before we get too far down that road. Excuse me. What's the rule that the court adopts?
So they,
And then we'll apply that to these circumstances. What's the rule the court adopts?
I said that a private employer can be held vicariously liable for the actions of an off-duty officer. And then they gave kind of three things. The actions occur within the scope of employment, the actions were taken in obedience of the employer's orders, and the actions were taken with the consent.
Do all three of those have to be shown?
I wrote or. I think it's just
Any one of
them,
the
yeah.
three. If any one of those three circumstances fit, the private employer can be held vicariously liable. So that's the rule that the court adopts. Now, apply that rule to these circumstances.
So as I said before, so Revco, it was the manager that told him to go do this. It wasn't anybody from the police department that actually told him to go serve this warrant. It was all the Revco manager that told him to go to the house. Now, yes, Boone did call the police officers and everything, but that's kind of the whole point they were making is it was kind of Revco who started this whole, it was the manager that started this entire thing and ended up with the man dying.
And Boone did what he did pretty much at the direction of his private employer, right? He did what he did, the court tells us, to serve the interests of the private employer primarily. And so if you look at the case that way, it's no great leap to then hold Revco vicariously liable. And that's what the court does. Now let me ask you this question. The court, at least in this opinion, doesn't express its view on the possible liability of Knox County or the Knox County Police Department. But the court does say that under certain circumstances, the public employer might be liable as well. That is, in addition to the private employer. So my question to you is, under what circumstances might the public employer be held liable when an off-duty police officer working for a private employer does something negligent?
I'll be honest, I didn't write that down. Did anybody get that one? Terrence?
I hear that these jurisdictions generally reason that because deterrence of crimes is further than private employment, police officers, private employers should be encouraged to hire such officers as police officers. That's what I agree.
Okay, but what about the public employer? The Knoxville Police Department.
There are four circumstances in which the municipality can be held liable, and they have to all be present. The action taken by the officer, when the off-duty officer involves exercise of the traditional police power, such as the power to arrest, the power to issue citations, or the power to command aid. The municipality acknowledged the actual or constructed of the action taken by the off-duty officer. The action taken by the off-duty officer simultaneously served the objectives of the private employer and the municipality, and the objectives of the private employer and the municipality, which are both served by the officer's actions, are not inconsistent with each other.
And as you say, a point of emphasis here, all four of those circumstances must be present in order to hold the public employer liable. Whereas with the private employer, it's any one of the three that you mentioned. A big difference in how the courts analyze private employer vicarious liability versus public employer vicarious liability. There's a lot in this case. A lot in this case of first impression. Let me ask you this. let's say you represent a private employer, whether it's a drugstore or some other business, it doesn't matter. You represent that business, and they come to you and they say, you know, we want to hire some off-duty police officers as security guards. Which, by the way, NSL does that very thing. So, what's your advice to these private employers? What would you say?
I would probably word it, don't overstep your boundaries, like understand that they're there to protect the store. They're kind of not your own personal police force. Just kind of be careful what you tell them what to do.
Like, for example, you might say, don't send them out to serve a warrant. And if you do think that's a good idea and you do it, don't summon them back to the store and then send them back out, because the more control you exercise, the more likely it is your business is going to be vicariously liable. And by the way, they might also ask you, what's vicarious liability mean? What's your answer?
That's a good question. I would word it, anything he does is going to fall back on you. If you have too much control over anything he does, can fall back on you. Maybe it'll be attached. It might not be an awesome way to put it. But.
Well, how about, that's certainly the gist of it. How else would somebody describe vicarious legal liability? Think very simply. Yeah.
You can be held liable even if you're not negligent. So even if just the employee's negligent and not you, you can still be held liable.
And then when they ask you, how come? Well, that doesn't sound fair. That doesn't sound right. I didn't do anything wrong, yet I'm going to have to pay a judgment. And your answer is yes. How come? That's going to be the next question they ask you. Why? Why am I vicariously liable?
Because at that moment you had control over the employee, because you told them to go do what it is they're doing, and they were acting in the scope of their employment.
Well, what if the guy, let's change the facts. What if this guard never even left the store? And, I don't know, got in a fight with somebody in the store? Why is an employer vicariously liable for the negligent acts or even intentional acts, as we're about to see, of an employee?
Because if there's a direct employer-employee relationship between the two, then you can automatically be held vicariously liable.
Yeah, and their question will be, why? How come?
Because they're on their job at that time.
Yes. They're on the job, and therefore,
The employer just called it a different standard, a higher standard.
see, you're thinking like lawyers. Just very simple, very basic. Yes, ma'am.
If you're gonna benefit the good part of it, you also have to own the bad part of it.
Okay, I like that. Yes, sir.
It's kind of like, I think of it as, you are only there as an employee at the pleasure, if you will, of the employer, so therefore your entire business there is bounded by that relationship. And so, because you're there for them, therefore, they ultimately have responsibility for something for something.
What you said is true, but if I'm paying you $500 an hour to give me advice, I just don't know that most directly answers my question. Yeah.
Is it because they are an extension of the employer?
Yes.
They're just one and the same?
Yes. That's it. That's it. So the business client, you can say, for legal liability purposes, you're one and the same. You and your employees are the same. They're just an extension of you. And if you look at it through that lens, well, it does make sense, does it not? To hold the business vicariously liable, even though the business did nothing wrong. When you put this case away and step out of some of these little details, what's the big takeaway for you? What does this case teach you about the law?
Kind of taught me that when you're looking at an off-duty police officer, that the court is gonna look, specifically in Tennessee, they're gonna look at scope of employment, the obedience and orders and directions from the private group, and the consent to do their actions.
Yeah, I think that's it. If any one of those three things are proven, the private employer can be held vicariously liable. It's a pretty simple concept, but it is a big deal. A big deal. Because of the practical impact that it has on businesses. Thank you, sir. So we've been talking about how the courts analyze the case when the employee commits a negligent act. What if the employee commits an intentional tort? Can an employer be held liable for that? Vicariously liable. When an employee commits an intentional wrong. Lisa M. unpacks this question for us. Ms. Hill, if you want to walk us through it.
So Lisa M. was a 19-year-old pregnant lady who was injured in a fall at a movie theater. And she sought treatment at the emergency room of Henry Mayo Newhall Memorial Hospital. The examining physicians ordered obstetrical and upper right quadrant ultrasonic imaging examinations. And after conducting the ordered examinations, the ultrasound tech left the room to develop the results. When he returned, he asked Lisa if she wanted to know the gender of her baby, and when she consented, he then used that opportunity to sexually assault her. He was later criminally prosecuted and pled no contest to a felony charge.
So this employee is not a negligent actor, he's a criminal. He committed a criminal act. And in our world of torts, we call that an intentional tort. What intentional tort would that be, by the way?
Sexual assault?
There's no such thing as sexual assault.
Assault? Battery?
Battery. Remember that from way, way back? In general terms, does vicarious liability apply when the employee commits an intentional tort?
Yes.
Yes. When?
When it is an extension of their scope of employment.
What do you mean by that?
When it is from an act that is foreseeable within the scope of their employment.
Okay, so the court tells us that, that an employer can be held liable even for the willful, malicious, and criminal torts that fall within his or her scope of employment. But then the court goes on to explain, in order for that rule to apply, there has to be a causal connection, a nexus, between the employment and the intentional tort, right?
Yes.
And the court then goes on to explain that, to say that basically what happened must be reasonably foreseeable. So that is the test in these kinds of respondeat superior cases. Is what happened, whatever it is, was that reasonably foreseeable? How's the court decide that and why?
In this case, the Supreme Court held that the hospital was not liable under respondeat superior because the actions of the employee were not foreseeable. The employee's conduct did not have a causal nexus with the employee's work.
So here you have a male technician alone in a dimly lit room with a female patient, and to some degree there's intimate touching that is necessary to do the procedure, right? So patient is in a vulnerable spot. Male technician is performing the ultrasound. The door is not completely closed, but pretty much, and is dimly lit. And the court concludes that the bad thing that happened was not reasonably foreseeable.
The technician's decision to engage in the exploitation of the patient did not arise out of the performance of the examination, although the circumstances of the examination made it possible.
The circumstances of the examination made it possible. What is it? Maybe can you say the same thing differently by just using the word foreseeable? That based on these particular circumstances, it might be reasonably foreseeable?
I think that the but-for cause part of it was foreseeable in that she was there for him to examine her, but then the nexus to link it to his employment was not there.
Yes, and so to take that a step further, the court explains that that the technician at the time of the tortious conduct was in no way serving the interests of the employer. That's a huge difference between this case and the one we just talked about. With Revco, Boone did what he did because Revco was pulling the strings. Hey, issued him a citation. Hey, go execute that bench warrant. Oh, you can't get in the apartment? Well, while you're waiting for a key, come back to the store because there's a shoplifter. Okay, now go back to the apartment. So the court concluded Boone was furthering the interests of the employer. You can't say that about this case. He did what he did for his own purposes. Did the employment make it possible for them to be together in this room? Yes. That's obvious. But at the time of the tortious act, he was not furthering the interests of the employer. Now, the court is divided in this one, right? So there's a dissent, actually two dissents. What's the gist of those? What problem do the dissenters have with the majority's holding?
A lot of the dissenters felt that there was an issue of material fact that should have been presented to the jury as far as whether or not he was within the scope of his employment.
Exactly. So the minority of the court concludes that, reasonable people could look at these circumstances and reach different conclusions about whether this is foreseeable. They don't go so far as to say we would hold the hospital vicariously liable, but at least put 12 people in a box, explain it all to them, and let them make that judgment call. Let me ask you this. This opinion focuses, and rightly so, on the hospital's vicarious legal responsibility. But you might remember when we began our discussion of vicarious liability last week, I said, don't forget that there's another way to get to the deeper pocket, i.e. the employer, that has nothing to do with vicarious responsibility. That is, if the hospital was negligent in its own right, you don't even have to worry about any of this. You don't have to get into scope of employment and foreseeability and all of that. So let's say you're representing this plaintiff. And your theory of recovery is not vicarious liability, but the hospital's negligence. What might your argument be? How might you convince a court that the hospital acted unreasonably?
I would say that they were negligent in, I don't know if this is reasonable, but having a male technician alone with a young female. There should have been another person in the room or the door open or something.
That would be my argument. You put a male technician in a room with the door closed and the lights pretty much off, and there's this sort of touching that is just part and parcel of the procedure, you're asking for trouble. So if I were representing the plaintiff, I would allege vicarious legal responsibility, or in the alternative, direct legal responsibility based on a notion that the hospital was negligent in creating this situation to begin with. I don't know whether I'd win that argument, but that would be my argument. I'm curious. We have 100 reasonable people in here. How many of you, after considering these circumstances, would find, if you were a juror, that this was reasonably foreseeable and therefore the hospital ought to be held vicariously liable? How many of you? Okay, put your hands down. So if you're going the other way, raise your hand. That is, the hospital should not be vicariously liable. Well, it's interesting. We're not quite evenly split, but it's pretty close. I'd say about 60% of you feel like the hospital, this is reasonably foreseeable, this event. And then then the 40% or so would allow the hospital to escape liability. Now, what about on the hospital's direct negligence? So take vicarious liability out of the equation. Now the plaintiff is asking you to hold the hospital liable for the hospital deviating from a standard of reasonableness in creating this condition. How many of you would hold the hospital liable? Okay, hands down. The other, going the other way. All right, now on that question, we are pretty much evenly split, which is interesting. Reasonable mind, I think what that illustrates, where I'm going with this, is maybe the dissenters had the better view. Assuming you all are reasonable minds, look at how you were split. You consider the very same circumstances and reach different conclusions. By definition, then this plaintiff should have had her day in court. So you put this one away. What's the big takeaway for you?
I know that I had my first child in 2003. I had a male obstetrician, and there was always someone else in the room. So it was interesting to me. I noticed this was 1995. I don't know what their procedure was prior to that, but in 2003, they did not have a male alone with a female. So it's interesting how it works its way through.
I have no idea what the current protocol is. Do any medical people maybe know? Or, I mean, what's the standard in your facility? Is it now a chaperone? Is there a third person in the room, or do we know? I have no idea. Yeah.
I'm not a medical person, but I did have a baby 2 years ago, and there was always, my gynecologist is male. Like, my actual doctor is male, and he would never be in the room, ever, not once. Even to this day, for all my regular appointments, he would always have a female nurse or somebody always in the room with me.
Yeah. So, anybody else? I mean, anyone? Okay, so let's say you represent hospitals.
Mm-hmm.
And your particular hospital, they do a lot of OB kind of work, and the administrator of the hospital comes to you, and he or she asks, well, got any advice for how we do testing like this? Any advice for us as healthcare providers when it comes to ultrasounds? What would you say?
My advice would be to always have a third person in the room to protect both sides of the equation.
What if you get pushback? And the pushback is it's expensive.
So
We gotta pay another employee. We gotta pay another employee to be in that room.
a lawsuit's expensive also.
Great answer. Great answer. Yes, it may be expensive for you, my client, but let me tell you, litigation is a whole lot more expensive.
Not to mention a reputation.
Not to mention a judgment. So I think if it were me, I would say the very same thing. Under no circumstance, absent an emergency or something unusual, where something has to be done very, very quickly. My advice would be always have a third person in that room. Always, always. Is there any way you can do it? Do it. You're just asking for trouble if you don't. Yeah.
I understand from a defense against lawsuits, having a third person in the room. So doesn't the things like massage studios and the one-on-one interaction, doesn't that whole concept, or for example, if I mean, there's a greater probability of unwanted contact in that context than it would be in the medical.
If I'm representing a business like that, I'm gonna make sure that business understands the potential ramifications of having a male and a female in a room together, door shut, lights dim. You're just asking for trouble. And then I'm gonna leave it up to my client. Hey, I've told you, I've given you the benefit of what I think. Now, you make a business decision as to how you conduct business. But I don't want one of those businesses coming back at me after they've been sued and say, why didn't you tell me? I had no idea about this foreseeability and this causal connection stuff. I didn't know. Lawyer, you should have told me. And I would have perhaps altered the way that I do business. Thank you, ma'am. So to take respondeat superior in particular one step further, which is the final step. What's the not only the legal but the practical import of a court finding that respondeat superior applies? Okay, so yes, there's this employer-employee relationship. And yes, the bad thing that happened, the Tortious Act, occurred in the scope of the employment. So what? The so what is the employer and the employee are jointly and severally liable. What that means then practically, so that's the legal significance. The practical significance is that the plaintiff can sue just the employer and recover, or sue just the employee and recover, or sue them both and recover in whatever combination the plaintiff chooses. They are jointly and severally liable, even though the employer was faultless. Now, as soon as I said that, I hope a red flag went right up the pole in your mind. What's the red flag? Anybody? What? Comparative fault? What about comparative fault?
It said that in Valentine, it said that there was no more joint and several liability now that there was comparative fault.
Yeah, you remember in part 5 of McIntyre where the court, we focused on the language even because that's a big deal, where the court said that because vicarious liability can impose fault, it can impose liability in a way that is disproportionate to fault, joint and several liability is obsolete. And that's the word the court uses. It's obsolete. So does that mean then that everything we've talked about so far all from here to here, does that mean none of that's good law anymore? If you consider what we've covered all last week and so far tonight, and the bottom line is the imposition of joint and several liability, and McIntyre versus Ballantyne says joint and several liability is obsolete, does that mean ipso facto all of this has been abrogated? Some of you are saying no. Some of your heads are shaking yes. Let me ask it a different way. And this is rhetorical. Have we just wasted our time?
No.
Wasted a whole week and now a week and a half? No, we haven't. So how can all of this still be good law, yet joint and several liability is obsolete? Well, so do I. How can all of this still be good law if joint and several liability is obsolete? Let that sink in just for a little bit. Let that sink in for a little bit. Now, what's your question?
Wasn't it just dicta in Valentine?
Well, yes, it's just dicta. But if the dicta is in a Supreme Court decision, you think the court in a subsequent case is going to say, we didn't really mean that. We just sort of threw that out haphazardly. Come on, lawyers and lower court judges. We were just messing around. We really didn't mean all that in Part 5. Well, it's dicta. Yeah, it's dicta. The court meant exactly every word of Part 5 of McIntyre. That was not a mistake. We're going to come back to this question here in just a few minutes. But first, let's talk about partners in a partnership. We've talked about an employer-employee relationship and how that relationship will trigger vicarious legal responsibility. What about partners? Are partners vicariously liable for the torts committed by other partners? The answer to that is yes. Assuming that those tortious acts occurred in the course and scope of partnership business. That's the common law. Tennessee has actually codified this common law principle in two statutes. One of them, I got them up there, 61-1-305 says this: a partnership is liable for loss or injury caused to a person as a result of a wrongful act or omission of a person acting in the ordinary course of partnership business. The partnership is liable for the wrongful acts, the tortious acts, committed by other people in that partnership in the ordinary course of partnership business. That is a statutory codification of the common law rule. The other statute is even more succinct. And it says all partners are liable jointly and severally for all obligations of the partnership. jointly and severally. Did that flag run up the pole again? Should have. How about this example? Let's say that after you graduate and pass the bar exam, which you will do, most of you. Let's say you go back to your community, your town, your city, and you want to open up a law practice. And one of your classmates is from that same town. And so the two of you shake hands and you open up a law practice together right there on the square. And you split the cost of some equipment, split the cost of a Westlaw subscription. You split the cost of renting a building on the square. You split the cost of administrative help. You're partners. But you don't work on each other's cases. You have your clients and your classmate / partner has her clients. And you don't, you got your business, your practice, and she has her practice, but yet you are partners in every sense of the word. Let's say your partner overlooks a statute of limitations deadline. And let's just assume, for sake of discussion, that she shouldn't have, that it was legal malpractice. She failed to calendar that particular date and missed the filing deadline, which is entirely possible. Those of you that work in law firms, you know that there are just dates, lots and lots of dates that you got to keep up with. You didn't know anything about that case. You never worked on it, never met that client, had nothing whatsoever to do with your partner's malpractice. And her client likes your partner. They're friends. So the client decides, I'm not going to sue her. I'm going to sue you. Because I don't know you. I have no relationship with you. So I'm coming after your car, your house, your bank account. Are you liable for the malpractice committed by your partner that you had nothing to do with? Yes. Yes, that's what these statutes say. That's what the common law rule says. Did your partner commit a tortious act in the course and scope of partnership business? Yes. That makes all the other partners vicariously liable. Even though they didn't do anything wrong, they are faultless. Another example. This one is actually a case. Thank goodness, not a Tennessee case. You know, well, you may not know, but there are some law firms that are just huge businesses. There are many, many partners, hundreds of partners, not counting associate lawyers and, paralegals and legal assistants and just huge, huge businesses. So big, in fact, that the partners often don't even know who all the other partners are. They have no relationship with them. They might work in a different city, maybe even a different country. Some law firms are that big. This particular firm was a big law firm, had a lot of partners. And a woman hired one of the lawyers in that firm to represent her in a divorce. Unfortunately, she hired a bad apple. And so this lawyer told her, and by the way, the custody of a child was the primary point of contention in this divorce. So this lawyer that she hired says to her, unless you have a personal relationship with me, I will actively work to lose custody of your child. And the client was like, okay, I don't want to lose custody of my child. Whatever you say, lawyer. And so they embarked on this personal relationship. Eventually, the client figured out something is amiss here. This should not be happening. And so she decided to see another lawyer in a different firm who told her, yes, this bad apple lawyer is committing legal malpractice big time, and you have all these claims that you could bring against him. And she said, fire away, let's sue him. And so she did. And she recovered a judgment against him for $225,000. It's a legal malpractice claim. $225,000 against this bad apple lawyer. And she recovered the same judgment against every single partner in that law firm who had no idea that this guy was doing what he was doing. No idea. Some of them didn't even know him. And yet, their car, their house, their bank account, their personal assets, they're just as liable as he is. There is no way on earth that I personally would form a partnership with another human being. Not a law practice, not a lawn care business, nothing. Nothing ever. And it's not because partners, I mean, if my kids were lawyers, they're not, thank goodness. If my wife of 40 years was a lawyer, there's no way I would form a partnership with any of them. Not because they would do something wrong on purpose, but mistakes happen. Negligence is by definition a mistake. I don't want their mistakes. I don't want to be vicariously liable for their mistakes. There's no way. Any business that I would form a partnership with a human being. If it's a true partnership. Now, I know some of you are thinking, well, can't you incorporate your part? Can't you design it this way in the voice? Yes, you can, but that's way beyond the scope of torts. I mean, when you get into like business associations and business law, you can like LLC a partnership. But if it is a true common law partnership, every partner in that partnership is vicariously liable. Jointly and severally liable, I should add. What about McIntyre versus Ballantyne? We're gonna get there.
Did she collect all of it?
What?
I said, did she collect all of it? Was no legal for it? Did she actually collect?
Okay, so $225,000 judgment against every partner in that partnership. What's the practical effect of joint and several liability? She can pick out any person or any combination. I want you to pay it. I want you to pay part of it, and I want to collect the other part from you. Joint and several equates to the plaintiff's choice. It always amazes me how many lawyers that know better, or should know better, will do just what I've described. Shake hands and open up a joint practice. They do it all the time. All the time. And some of them regret it later on. We talked about employers and employees. We talked about partners. Now let's go on to the next relationship, which is that exists between an employer and an independent contractor. So unlike employers and employees, and unlike partnerships, the rule here is that an employer is not vicariously liable for the torts committed by an independent contractor. An employer is not vicariously liable for the torts committed by an independent contractor. The thought is, or the rationale for the rule, is that because the employer doesn't control the means and methods by which the independent contractor does their work, the employer ought not be held vicariously liable. So that's the rule. The litigation in this area centers not so much on that rule, but on whether that wrongdoer is in fact an independent contractor as opposed to an employee. Nobody really disputes the rule. But where the cases tend to focus is on the question of whether the tortious actor is an independent contractor vis-a-vis an employee. That question is paramount because, as you know, if the court characterizes them as an employee, the employer is vicariously liable. If the court, on the contrary, characterizes them as an independent contractor, the common law rule says the employer is not vicariously liable. This brings us to the next case, Youngblood versus Wall. Mr. Clark, tell us about this one.
Okay, Youngblood versus Wall. So Court of Appeals, Tennessee, 1991. Defendant Greenberg worked with plaintiffs to purchase a house of which she was the listing agent and to sell their property, the plaintiffs. Plaintiffs were highly leveraged financially and could not obtain financing. So defendant Greenberg assisted them, even directed them to fraudulently fill out loan applications using fake tax returns, then intentionally.
Back up a little bit.
Yes, sir.
So, factually, this case starts out as about as simple as you can imagine. The plaintiffs are looking to buy a house. And we're told that while they were on a Sunday afternoon drive, which I thought was curious. I mean, does anybody ever just, is that a thing? Do you ever just on a Sunday, let's just get in the car and let's just drive? Gas is not expensive. Let's just get in the car and waste a bunch of gas. Some of you are shaking your head. Yeah, this is a thing.
It was the 80s.
What?
It was the 80s.
Okay, yeah, all right. But some of your colleagues still do that, apparently. So they're out on a Sunday afternoon drive, and they, look at that house for sale. Let's try to buy that house.
Right.
Now, they connect with
Greenberg. She was the listing agent of the house.
And they begin the home buying process, yes?
Yes.
And there are some problems, and this is where you were headed, some problems with the buyers / plaintiffs' credit history.
Yes.
What was one of those problems?
They have 3 mortgages on their current house. That's one problem. They have, at least Mr. Youngblood, I think, did not file tax returns for 1985 and 1986. That's another problem.
Yeah, that's a big problem. Rarely is it productive not to file tax returns. What's another problem that they have in their
What am I missing?
Their history, their credit history?
Risky credit rating. I'm not sure what you're shooting for here. Oh, yeah, they had a business property that was foreclosed on and then burned down within weeks. I forgot about that.
All right, so they owned a business, owned a building. They couldn't pay the mortgage company foreclosed, business mysteriously burned, arson was suspected, and the insurance company decided to pay the mortgage company, but not pay the Youngbloods anything. And arson was suspected. Well, there's that. Now, as far as the tax returns, how did the parties seek to address that problem?
Greenberg gave them numbers that she thought would work for loan approval and told them to fill in some backdated tax returns and submit those as proof of tax return.
You know, you just see this. I mean, this starts out very simply, but it quickly becomes very complex, if not criminal. Certainly tortious, but I'm sure criminal as well. called mortgage fraud. So Greenberg got some tax returns from other people that she had represented that she knew and so she knew that they were approved for a loan like this. She supplied that to the Youngbloods, and the opinion tells us that either they falsified tax returns or she did. Neither of which is good. So while this is going on, what had the Youngbloods, what had they done?
In the meantime, they listed their house with her. They did find a buyer, but by October, late October of 1987, they had actually moved in
They moved into the
to
house.
the new house without having a loan funded.
It's not their house. They moved in the house. Don't you see this? I mean, as you're reading the story, didn't you just get this sense of, okay, I see this house of cards going up, and you know at some point the whole thing is going to come crashing down. And it does. So with these fake tax returns, what does Greenberg then do?
She starts applying at different places, more or less without the Youngbloods' knowledge, all of which get declined.
Yeah, every lending institution that she submitted their loan package to declined. Did she tell the Youngbloods this?
She told no one.
But they're in the house and they got a closing date coming up.
It's true. They do have a closing date coming up, and so she went about finding other avenues for funding that.
At what point does she tell the Youngbloods, we don't have permanent financing to make this deal work?
Until the day before closing.
The day before they're set to close. You talk about a house of cards. But the plaintiffs say she encouraged us, hang in there, permanent financing is just around the corner, it's all good. And they started getting cold feet. And they went to her at one point and said, you know, maybe all of this is not a good idea. Maybe we should just back out. She's like, no. You're already in the house. Let's just keep churning this. So what happens next? How does she keep churning this?
Well, she got the buyer of their property to cover most, if not all, of the second and third mortgages that they had, with a 60-day note, I think. And they got a 90-day bridge loan from First Southern Bank to cover the amount for the new house, the Central Valley house.
And who co-signed that loan?
That would be the broker, I think.
Yes, that's Snow and Wall. So things still they get more and more complex. What happened next?
They did try backing out. They were convinced not to. So then they did not pay the note within 60 days for the second and third mortgages that they owed to the buyer of their house, and they got foreclosed on the 90-day note with First Southern. And so the brokerage ended up stepping in and paying for that, foreclosed on them by doing so.
So the house of cards collapsed. The whole thing fell apart. The Youngbloods at that point tried to file bankruptcy. And the bankruptcy court turned them away. You know, when the bankruptcy court turns you away, you're really in a lot of trouble. And then we have this lawsuit where the Youngbloods sue Greenberg and they sue Snow and Wall. One of the issues is whether Greenberg committed fraud. Which, if you just imagine in your mind's eye, every tort we've talked about so far this year, all of them. If you just imagine the rungs of a ladder and just rank those torts in terms of culpability, fraud would be at the very top rung. Did Greenberg commit fraud? According to the court.
I don't recall the court.
Well, if she didn't commit fraud, this case is over.
By her actions, Greenberg breached her duty to the Youngbloods. This breach of duty amounted to tortious conduct toward the Youngbloods, for which Greenberg is liable.
So did Greenberg commit fraud?
Yes.
Was that a guess? Yes.
I mean, I don't see it spelled out here.
Well, it is spelled out here.
I must have.
Maybe you call on one of your colleagues.
Anybody have that
Greenberg
specifically?
committed fraud.
Mr. Lamb?
Yes, she committed fraud.
Yes, she committed fraud. Court finds she committed fraud.
Where does it say that?
Well, we'll run that language down here in a minute. But
Okay.
we got to get through the issues. Greenberg commits fraud, the court finds. That leads to the next question, which is what makes this case significant legally, which is, was she an independent contractor or was she an employee? Snow and Wall argues, well, she was an independent contractor and therefore we're not vicariously liable. Plaintiffs argue she's an employee, therefore the deep pocket, Snow and Wall, is vicariously liable. So my question to you then is this: how do courts determine whether someone is an employee vis-a-vis an independent contractor?
There are 9 relevant factors. List them out?
Okay, I'm not going to ask you just to read all 9 of those, but there's one factor that's most important.
The most indicative of an employer-employee relationship than any of the others is that the employer has a right of control over the work done for him, her.
Is it required that the employer, in fact, exercise that right, or just that the right exists?
It is just enough that the right exists.
Yes. All right. So, is she an employee or an independent contractor?
She's an employee.
What makes her an employee?
She had been affiliated with Snow and Wall for 16 years. Snow and Wall, sorry. She maintained her office in their agency building. No evidence that she paid rent or utilities. She was engaged in the regular business of Snow and Wall. And the sale of the Central Valley property that she was the listing agent for, Snow and Wall was actually the agent. So
What
she
about
worked for them.
What about this right of control?
The right of control, they cited that there is evidence in the record that Snow and Wall not only had the right to control the performance of the work, but they exercised that right as well. They were involved with some of the bridge money that was obtained. Mr. Wall controlled the activity of Greenberg to the extent when Youngblood came to her after the Walls had foreclosed on him, Mr. Wall told Greenberg to have no further discussions with Youngblood, and she obeyed this command.
Yep. So in this case, not only was there the right to control, but that right was actually used. It was exercised. So the court concludes that Greenberg is an employee. Now, that leads to the last issue, which is whether an employer can be held liable even for the frauds and misrepresentations committed by an employee.
Yes, the employer is generally liable for the frauds and misrepresentations of his employee made within the scope of that employment, even when he has no knowledge thereof, under the doctrine of respondeat superior.
That's pretty tough medicine. So let's say you represent this employer and you get this opinion back and they see that they have lost. And they ask you, why are we liable for what she lied to these people. She misled these people. That's fraud. She made all these misrepresentations. Oh, hang in there. Permanent financing is just around the corner. When she knew full well that was not the case. And so your client asks you, why am I liable for this fraud that I knew nothing about?
My question, I would respond to that with another question. Why did you know nothing about it? It's your responsibility to know what is going on with your agent. You're responsible.
Well,
and then I get fired and I hire somebody else.
No, I mean, well, okay, so your client's going to respond. She's sneaky. I mean, you don't run around waving a flag. I'm committing fraud. Look, I'm misleading people. I'm lying to people.
Right.
We had no reason to know that this was going on. So why are we liable?
You are liable because she is your employee, and she is an extension of you.
There you go. That's it right there. That is at the core of respondeat superior. Employees are extensions of employers. Partners are extensions of partners. And again, if you look at it through that lens, it makes sense that the employer or the other partners would be vicariously liable, even though they're faultless. Not just vicariously liable, but I would add jointly and severally liable. And there goes that red flag again. What about McIntyre versus Dobbs? We'll get there, I promise. Okay, so, the same question to you. What's this case teach you about the law?
It's good to see that sometimes Not all the time, but sometimes bad actors get what's coming to them.
Agree 100%. But what's it teach you about the law? What do you now know that you didn't know before you read this case about the law?
Well, honestly, I always thought the real estate agents were independent contractors, and I now know some criteria on how to determine whether or not that's actually the case.
Now you have an analytical filter to use when deciding, okay, is this wrongdoer an employee, which triggers these rules, versus an independent contractor, which will trigger different rules. You're now armed with that filter. The other big takeaway from this case, I would suggest, is that an employer is liable even for the frauds committed by an employee committed within the course and scope of the employment. So it's just not negligence. It's even something as bad as fraud when the employer doesn't even know about it, much less not participate in it. And it goes back to you're an extension. That wrongdoer that you hired as an employee, that's an extension of your business. Thank you, sir. Time is not our friend. Why don't we do this? Next week, let's only finish what was on the syllabus for tonight. And because of the change in our schedule that the school has made, we have the luxury of pushing everything off a week and still be in great shape. So let me say that again. Next week, all we're going to do is finish what is on the syllabus for tonight. Okay? Yeah.
Speaking of that, do you mind uploading like the updated syllabus into TM so we can download it? Because
You can't just push everything off 1 week.
well, no, it's just the other one you gave us was the paper copy, so you never even uploaded that one to Twin, and so we had to scan. Like I had to scan it in to get it.
Oh.
You see what I'm saying? Like it doesn't matter which one you upload. I don't care if you edit it. I'll edit it, but can you just upload the Word document?
I'll do my best.
Thank you.
Okay, so we're all clear on next week, right?
Yes.
All right, make sure I get the roll. See you next time.
Thank you. Oh, those are the ones that you